This case considered the issue of theft, and whether or not a car dealer's method of selling motor vehicles was dishonest, even though he did not intend that the parties concerned would suffer any loss. In this case, a second-hand car dealer was convicted of theft and dishonestly obtaining property by deception, after he had received cheques given to him by the purchasers of motor vehicles that he was holding to sell on consignment. He had deposited these cheques into his own trading account and not into a trust account, which was a requirement for car dealers. He had also managed to sell the vehicles without removing the charges over the vehicles for various forms of finance. Soon after, he filed for bankruptcy due to financial difficulties. He appealed these convictions on the basis that even though he could no longer pay the sellers of the vehicles, that he never intended that the sellers of the motor vehicles were to suffer any loss, and that he had acted in good faith, and furthermore that he had not claimed any right in the title over the vehicles. The prosecution argued that in order to legally sell the vehicles, he had to have a clear title in the vehicles, so that when he was selling them, he was purporting to have such a title in the motor vehicles, and that since he had not actually done this, that this amounted to deception. The central issue for the court, therefore, was whether or not the judge's directions relating to dishonesty were correct, or whether or not the car dealer was entitled to rely on the defence that he intended no one to suffer any loss as a result of his actions. The court ultimately held that